standards for judicial review if a person has been adversely affected or aggrieved by an agency action. The final rule is then published in the next edition of the Code of Federal Regulations, but without the supporting documentation, published in the Federal Register. Second is the Congressional Review Act. That requires that a rule not take effect until after an agency submits a rule report to each House of Congress and the Comptroller General of the United States. A rule that is major may take effect no earlier than 60 calendar days after the Congress receives the rule report. The Act also provides procedures by which Congress can rescind a rule within a specified period of time using expedited procedures. As an example, mandatory discharge from the Committee of Jurisdiction and no filibusters allowed, though this is rarely attempted. However, it could become extremely important if modified, as currently proposed, to require affirmation of major rules. The rule report must include a copy of the rule, a concise summary, whether the rule is major, and the effective date. A rule is major if it results in an annual effect on the economy of $100 million in a year or certain other specified impacts. The third is an executive order, 12866, titled Regulatory Planning and Review. It applies only to executive agencies, though the President has formally requested that independent agencies abide by its spirit. It requires that significant, quote-unquote, regulatory actions be submitted with a regulatory impact analysis for review by the Office of Information and Regulatory Affairs, hereafter OIRA. It's in the Office of Management and Budget. A significant regulatory action, as defined by the executive order, generally is any regulatory action that is likely to have an annual effect on the economy of at least $100 million per year or certain other specified impacts. Since OMB reports to the Executive Office of the President has more influence over the executive agencies such as IRS, which is in Treasury, or in OSHA, which is in the Department of Labor, than over independent agencies such as EPA, FCC, and the Federal Reserve. Next, let's look at the size and the rate of growth of the body of federal rules and regulations. The annual Federal Register surpassed 80,000 pages for the first time in 2010. 25,000 of those pages were final rules, including supporting documentation. The U.S. Code has 47,000 pages of statutes. By contrast, the Code of Federal Regulations has 165,000 pages, comprised of rules and regulations, but without the documentation required in the Federal Register. So they're pure rules. These come from over 300 agencies, independent and executive, including OELA, Office of English Language Acquisition, JABIA, Joint Board for the Enrollment of Actuaries, and KPDBZT, Committee for the Purchase from People Who Are Blind or Severely Disabled. So we have a lot of agencies, many of them special purpose. Based upon reporting by the Competitive Enterprise Institute, in the first 3 years of the Bush administration, more regulations were published than in the first 3 years of the Obama administration. But in the Bush administration, only 30 economically significant rules, more than $100 million, were promulgated, while in the Obama administration, 950 rules were promulgated, 30 times as many. According to mandatory agency reporting, in the first 3 years of the Bush administration, final rules significant to small business were promulgated 16 times, and in the Obama administration, 257. That's 16 times as many. A paper by Jerry Ellig at George Mason University showed that OIRA studied major rules for an average of 56 days each in 2008, 27 days each in 2009. OIRA studied Obamacare interim final rules for an average of 5 days each in 2010 due to the urgency of publication. The President's 2012 budget called for federal regulatory expenditures of $57 billion and a staff of 292,000 FTEs, full-time equivalents, about 10% of the civilian federal workforce. A 2011 study of federal regulatory agencies by researchers at George Washington University using constant dollars found that between 2000 and 2012, population increased 14%, regulatory FTEs were up 66%, and agency budgets were up 75%. Between 1990 and 2012, population increased 28%, FTEs 91%, budget 166%. And finally, between 1960 and 2012, population increased 80%, FTEs 410%, budgets 1,600%. A 2011 study by economists Nicole and Mark Crane for the Small Business Administration, which incidentally is disputed by OIRA, they don't agree with it, calculated annual federal regulatory compliance cost to be $1.7 trillion. This is 50% of the size of the federal budget. It's 12% of gross domestic product and is greater than total corporate pre-tax profits in the United States. An older study for the SBA's Office of Advocacy found that compliance for environmental regulations for small businesses, fewer than 20 employees, upwards of 6 times as much per employee as that for large businesses, 500 employees or more. This is significant because small business is more prolific job creator than our large business. The most recent of a required annual federal report showed that 58 federal departments, agencies, and commissions had 4,225 rules in the pipeline, of which 224 were economically significant. Next, let's look at some of the important players in federal regulation, many of whom are law school graduates and progressive devotees of expansion of the regulatory state. Starting with Barack Obama, a Harvard law grad, who said if somebody wants to build a coal-fired power plant, they can, but it's just that it will bankrupt them because we're going to charge them so much for greenhouse gases. Cass Sunstein, former Chicago law professor and current administrator of OIRA, he wrote a 2004 book, The Second Bill of Rights, which advocates Franklin D. Roosevelt's initiative for individual positive rights to a good remunerative job, a good education, a decent home, and adequate health care, all presumably guaranteed by the state, which creates a concomitant obligation for the half of citizens who pay income taxes. His later book, Nudge, presumes individual irresponsibility and a lack of common sense. It prescribes nanny-state guidance of the masses by government policy incentives created by well-informed elites. Carol Browner, law grad and former EPA administration under the Clinton administration, and White House energy and climate czar under the Obama administration. She was a chief pusher for cap-and-trade legislation until her position was eliminated in 2011. She is co-founder of the Center for American Progress, the left's leading policy shop, a member of Socialist International's Committee for a Sustainable World, and is quoted as having said, "Global warming is the greatest challenge ever faced." Jack Lew, Chief of Staff and former Director of Office and Management Budget, which is over OIRA, and a law grad. He chaired former Vice President Al Gore's Green presidential run in 2000. Lisa Jackson, current EPA Administrator and a chemical engineer. Maybe I should give her a pass as a fellow engineer. When asked about massive new EPA rules and resulting coal plant closings, she replied that EPA's role is to level the playing field, referring to making coal plants uncompetitive through emission regulations. Richard Griffin, NLRB Commissioner, recess appointed by Obama, previously served as General Counsel for the International Union of Operating Engineers, a lawyer. He is one of 4 recess appointments by Obama. The commission has 5 members and gained notoriety for trying to block Boeing from building aircraft in a right-to-work state, trying to shorten the time needed for union elections by eliminating adjudication of an employer's legal challenges before the election, and promulgating a final rule effective January 31st, requiring most private sector employers to post an 11 by 17-inch notice provided by the NLRB informing workers of their right to unionize. Per Wikipedia, our Supreme Court has 5 graduates of Harvard Law, 3 from Yale Law, 1 from Columbia. Only these 3 law schools have produced more than 3 justices in the entire history of the Supreme Court. Harvard with 18, Yale with 10, Columbia with 7. The Congressional Research Service reports that nearly 40% of House members and 58% of senators have law degrees. Per Wikipedia, in a different Congress, there were 56 senators with law degrees, of whom 51 were Democrats. Finally, let's look at law schools themselves. According to Cato Institute scholar Walter Olson, in his recent book, Schools for Misrule, law faculty Democrats outnumbered Republicans 23 to 1 at Columbia, 28 to 1 at Stanford. Harvard, he alleged, had once gone 30 years without hiring an identified Republican under their faculty. His data showed that in 2008, law faculty nationally contributed 10 or 20 times, they don't know exactly, as much to Democrat as to Republican presidential contenders. Harvard Law graduate, but libertarian-leaning Professor Randy Barnett of Georgetown Law comments on the book. He provides the inside story of how progressive political ideology became the reigning orthodoxy of elite legal education, providing the legal theories responsible for an overweening government committed to mandating, prohibiting, or regulating every aspect of American life in the public interest. My own research found that Harvard Law has an Office of Public Interest Advising to encourage students to enter public service. Their public service venture fund awards $1 million a year in grants after graduation to help young lawyers pursue careers in public service, not necessarily as politicians or elected government employees. Another program waives third-year tuition for those who commit to the first 5 years of service of their careers in public service. Additionally, nearly $3 million a year in fellowships are given to students who just a claimed interest in public service. Quoting venture fund advisor Rebecca Ani, class of 2003, the fund enables, quote, pursuing multidisciplinary, unconventional pathways to achieve social justice. So, based on this body of evidence, I submit that federal regulation, government regulation, is bigger, more intrusive, more ideologically based, more protective of political favorites, and more expensive to the economy than ever before, and that the folks who are driving the regulatory bus are going to bring us a lot more of the same. This promotes uncertainty regarding compliance cost and economy-chilling fear of ever more to come. It also provides enormous opportunities for corruption, manipulation, and regulatory capture. Let's look at some examples of how the rulemaking process is abused and misused. Beginning with the Congress, it has been guilty for years of making overly broad laws and, in effect, delegating the responsibility for legislating to the executive. Politically, it takes credit for perceived noble goals, saving the planet from global warming, preventing another financial crisis, providing affordable housing, providing affordable health care for all ad nauseum. Then later, Congress can blame the agencies for their excesses and represent their constituents in dealing with the regulatory monster. Article 1, Section 1 of the Constitution gives Congress the authority to legislate, no other body. Remnants of the so-called non-delegation doctrine can be traced to the writings of John Locke in his second treatise on government, which informed the work of the framers of the Constitution. Quoting, "The legislative cannot transfer the power of making laws to any other hands, for it being a delegated power from the people. They who have it cannot pass it over to others. The legislative power is to make laws, not to make legislators." Remnants of the intelligible principle requirement, intelligible principle, which still controls what's left of non-delegation court cases today, is traceable to the writings of Chief Justice John Marshall, who in 1825 wrote, "If Congress delegates quasi-legislative powers to another body, it must provide a general provision by which those who are to act can fill in the details." This was formalized in a Supreme Court case, J.W. Hampton v. United States, in a case involving the Tariff Act of 1921. Wherein the court said, "Such delegations are constitutional as long as the Congress shall lay down by legislative act an intelligible principle to which the person or body authorized is directed to conform." Unfortunately, later decisions allowed greater delegations, starting with FDR's second term, when he threatened to pack the Supreme Court after it overturned some of his expansive creations in the New Deal. But the final nail in the coffin, which nearly eviscerated the non-delegation doctrine, came just a decade ago. Bob Levy, chairman of the Cato Institute, and Chip Miller, president of the Institute for Justice, in their book, The Dirty Dozen, nominate Whitman v. American Trucking Association as one of the dozen worst decisions of the Supreme Court. For all practical purposes, the court removed the non-delegation doctrine. In Whitman, the court essentially rewrote Article 1, Section 1 of the Constitution to read, "All legislative powers herein granted shall be shared between the Congress of the United States and several hundred unelected agencies." As Roger Pilon, Vice President of Constitutional Studies at the Cato Institute and frequent speaker to Federalist chapter meetings, reminded me, Fred, you shouldn't confuse the Constitution with constitutional law. The current state of affairs has facilitated and fostered ideological promotion, protectionism, regulatory capture, agencies making regulations without congressional authority, detailed rulemaking that ignores individual responsibility and common sense, poor or absent cost-benefit analysis, issuance of poorly drafted so-called interim final rules, and more. The cost of the economy is enormous. The attendant uncertainty is a damper on business decision-making and hence investment. Some agencies are effectively independent, not wholly accountable to either the President or Congress, exercising legislative, executive, and judicial powers. The Food and Drug Administration, for instance, can issue regulations having the same effect as statutes, impose penalties for violations, and conduct trial-type proceedings that affect the rights and interests of particular parties. EPA is famous for similar heavy-handedness. The 59 independent agencies listed on the federal government's website are not subject to the oversight by OIRA. It include the EPA, EEOC, FCC, FEC, NLRB, and SEC. They wield enormous discretionary authority in interpreting their enabling statutes and enforcing the resulting rules and regulations. However, all of these entities are subject to the intimidating but seldom fully used Congressional Regulatory Act. More on that later. Let's consider some examples of abuse or misuse. Excuse me. Number one, the Office of Federal Contract Compliance Programs, with which I am familiar. I spent a lot of time as a defense contractor, recently proposed a regulation which is a good example of social engineering. The proposed rule is for government contractors to have 7% of their employees disabled, 2% severely disabled. An unintended consequence is that employers, under the Americans with Disabilities Act, are not allowed to ask if potential employees have a disability. So the rule contemplates a fan dance of invited self-identification. Perhaps frustrating to an employer is that an employee hired with the quota in mind may find out that the employee does not have a disability at all. Dang, and she looked so disabled. In a bow to auto unions, Congress required that the National Highway Transportation Safety Administration, hereafter NHTSA, mandate that auto companies must comply with 2 CAFE fleet mileage standards, one for cars assembled inside the United States and another for cars assembled outside the United States. The effect of this distinction is that automakers are forced to assemble an uneconomic proportion of small cars in the country. Automakers prefer making small cars in low-wage countries due to the relatively higher labor content in small cars. A single CAFE standard would have produced the same mileage result, but with fewer cars being built with UAW labor. Number 3, Sarbanes-Oxley, enacted in 2002 following scandals at Enron and WorldCom and other, created new and enhanced accounting standards for public companies and a new agency, the Public Company Accounting Oversight Board. Dozens of rules were issued by the SEC, including additional corporate board and officer duties with criminal penalties relating. A recent report documents that the result on the number of companies going public was devastating. Compared to the decades of the 80s and the 90s, the last decade saw an 80% reduction in U.S. IPOs, initial public offerings, which no doubt accounts for Congress's recent passage of the JOBS Act, which will exempt companies with less than $1 billion in annual sales from much of Sarbanes-Oxley, for their first 5 years. The JOBS stands for Jump Start or Business Startups, and the President is expected to sign it. The Senate has already passed it. Number 4, a perfect example of excessive congressional delegation is IPAB, the Independent Payment Advisory Board, created by PPACA, the Patient Protection and Affordable Care Act, popularly known as Obamacare. Columnist George Will explains that the IPAB, a perfect expression of the progressive mind, is to be composed of 15 presidential appointees empowered to reduce Medicare spending, which, by the way, is 13% of the federal government spending, to certain stipulated targets. IPAB is to do this by making proposals or recommendations to limit costs by limiting reimbursements to doctors and hospitals. PPACA, the law, repeatedly refers to IPAB proposal as a legislative proposal and speaks of the legislation introduced by IPAB. Each proposal automatically becomes a law unless Congress passes a measure reducing medical spending in an amount equal to the amount that the IPAB proposal would have reduced it. This is a travesty of constitutional lawmaking. An executive agency makes laws unless Congress enacts legislation to achieve the executive agency's aim. And it gets worse. Any congressional resolution to abolish the IPAB must be introduced after January 1 or before February 1 of 2017, a 31-day window during which a president will take the oath of office, and must be enacted by August 15 of 2017, and if passed, it cannot take effect until 2020. Its constitutionality in binding future Congresses, as you might expect, is being challenged. Number 5, Mike Tanner of the Cato Institute wrote recently about proposed Medicare diagnostic codes, which display an incredible regulatory prescriptiveness. On February 16, just recently, Health and Human Services Secretary Kathleen Sebelius announced that HHS must delay implementation of new diagnostic codes for Medicare. The new regulations were endorsed in 1990 by the United Nations World Health Assembly, but not adopted by the U.S., which currently operates with predecessor codes. However, a final rule was published by Health and Human Services early in the Obama administration requiring adoption of the UN World Health Organization's 10th International Classification of Diseases with a compliance date of October 1, 2013. Due to pushback from healthcare providers, the date has been made indefinite. When it takes effect, it will increase the total number of classification codes from the current 18,000 to more than 140,000 codes. But physicians will now have additional time to try to understand the bureaucratic complexity of rules that, for example, apply 36 different codes for treating a snake bite, depending upon the type of snake, its geographical region, and whether the incident was accidental, intentional self-harm, assault, or undetermined. The new codes also thoroughly differentiate among 9 different kinds of hang gliding accidents or injuries, 4 different types of alligator attacks, and the important difference between injuries sustained by walking into a wall and those resulting from walking into a lamppost, and whether it was the first time, the second time, or more. And if you'd like to see the rule, I've brought it with me.
Can you explain what an intentional snake bite is?
You're committing suicide.
Creative.
The administration apparently agrees with the United Nations that we just need more data. Number 6, there'll be 7 and we're done. The Economist magazine recently published a critique of the nearly 1,000-page Dodd-Frank Wall Street Reform and Consumer Protection Act. This was enacted in response to the financial crisis of 2008 and signed into law in 2010. They wrote, "Laws classically provide people with rules. Dodd-Frank is not aimed at people. It is an outline directed at bureaucrats to create more new bureaucracies to make more regulations. Like PPACA, it is a clear violation of the non-delegation doctrine." Sections 404 and 406 run a couple of pages in Dodd-Frank, but resulted in a 192-page form to be filled out by hedge funds and other financial institutions. The cost to a firm of completing it is estimated at $100,000 to $150,000 first time and $40,000 a year thereafter. Due to uncertainty about hundreds of as yet unwritten rules and the estimated cost of known rules, most large bank stocks are trading below book value. Low valuations makes it difficult to raise capital that would allow them to lend more, as the politicians would prefer. Inevitably, banks themselves are adding to the cost with a vast lobbying effort. And in supreme irony, Dodd-Frank hardly touches Fannie Mae and Freddie Mac at all. These are the government-sponsored entities that received the largest bailouts in 2008 and are more important in the housing market now than ever. They plus the FHA, the Federal Housing Authority, own or guarantee half of all home mortgages in the United States. Bloomberg News in January reported that the situation has gotten worse. Fannie, Freddie, and FHA currently back 90% of home loan originations, about double what they did during the subprime lending boom. Finally, the Green Obama administration failed to enact cap-and-trade legislation to regulate CO2 emissions. So, after EPA issuing a finding that CO2 is a pollutant under the Clean Air Act of 1970, it is trying to achieve its ideological aspirations without the Congress. EPA can't regulate fuel economy, but effectively has, by setting limits on tailpipe emissions. As the 2010 tailpipe rule explains, CO2 constitutes 95% of the greenhouse gases in auto emissions. And the only way to reduce emissions is to decrease the amount of fuel used. So they negotiated an agreement with NHTSA, the state of California, which regulates fuel consumption also, and the auto companies to reduce CO2 emissions by increasing fleet average fuel efficiency. EPA parlayed that authority into rules for power plants, which will effectively prevent the future construction of coal-fired power plants and shut down some older ones. Transportation Secretary Ray LaHood and EPA Administrator Lisa Jackson jointly announced last November a proposed rule setting farther out fuel economy standards out to 2025, bragging that, quote, "We can't wait for congressional Republicans to act." The only way car makers can reach the 54.5 mile per gallon final goal is to act on incentives built into the rule, which give electric, hybrid, and natural gas fueled vehicles a break in the method of calculation for the average, fleet-wide average. For example, one electric car counts as two cars with zero fuel used. So you can see the result of we'll have a conventional fleet with an average probably about 40 miles per gallon and lots of electric cars, a stated administration goal. This ignores, of course, the fact that electric vehicles largely run on electricity that's made in coal-fired power plants. As an aside, my son, who is a fellow in regulatory studies at the Competitive Enterprise Institute in Washington, has numerous examples of regulations that just make one wonder. A Federal Railway Administration regulation requires a large F be displayed on the front of the lead locomotive to indicate which is the front of the train. A Texas law declares that when two railroad trains meet at a crossing, each shall stop, and neither shall proceed until the other has passed. A Florida law requires vending machine labels to urge the public to file a report if the label is not there. I could go on. So, if we were to agree that we have too much federal regulation, what could we suggest be done to reduce it? Assuming the big assumption that we have a president and majorities in both houses of Congress who also agree, there are several areas of beneficial reform that they could pursue. One is to simply repeal or replace key statutes, such as Dodd-Frank and the Patient Protection and Affordable Care Act and Sarbanes-Oxley. Another is to override certain regulatory rules and limit the authority of agencies by statute. When and if the politically correct belief that global warming is a crisis goes out of vogue, revoke the EPA's finding that CO2 is a pollutant and remove EPA's authority to regulate CO2 emissions. Disallow authority of states, read California, to set competing fuel economy standards and limit NHTSA's ability to set such standards to only those which are justified by an independently provided favorable cost-benefit analysis. Disallow adoption of the latest UN medical diagnostic codes for obvious reasons. Another is to reform the rulemaking process, again by statute. Require that cost-benefit analysis for major rules be performed by an independent agency. Codify in the statutes the requirements for rulemaking contained in Executive Order 12866 that I mentioned earlier, which would facilitate judicial challenge to rules in addition to their oversight by OIRA. Make independent agencies such as EPA, EOC, FCC, etc., subject to the same oversight as the executive agencies are. Another beneficial area of reform is decreasing the amount of delegation in congressional law by requiring intelligible principles in statutes, requiring that rules be sunsetted after 5 years and have to be reapproved, requiring that Congress approve all economically significant rules, create a Congressional Regulatory Analysis Office similar to the Congressional Budget Office, establish a bipartisan Regulatory Reduction Commission to assemble reductions to be voted upon by Congress, require an annual regulatory compliance cost report card to accompany the annual budget, Interestingly, there are 3 regulatory reform bills which passed the House recently, in addition to the Jobs Act, which I mentioned earlier. H.R. 3010, Regulatory Accountability Act, H.R. 10, the REINS Act, R-E-I-N-S, Regulations for the Executive in Need of Scrutiny. I love the names. H.R. 3309, which requires cost-benefit analysis for all FCC proposed rules. These bills incorporate many of the ideas for reform that I've mentioned. Unfortunately, the current Senate is unlikely to take up the bills, and the current president would likely veto them. But, much like Congressman Paul Ryan's budget bill, they provide specific ideas and a template to be taken up by future Congresses and to be debated in election campaigns. In the meantime, there are many constituents for the status quo. They are the ideologues populating much of the regulatory structure, company lobbyists seeking protection from competition, special interests seeking promotion of their causes, and those who just like big government. If, however, we can reduce regulatory costs, the result will be much greater economic growth and in turn increase tax revenue and provide much needed assistance for reducing our federal deficit. I hope this talk has refined your awareness of the size, scope, and the cost of the regulatory state, and that you'll be interested in improving and limiting the role of federal government regulation going forward. Thank you for your attention and for this opportunity to speak to you today. I look forward to hearing your thoughts on the subject of regulation and perhaps on the role of top law school faculties and lawyers in public service. Thank you.
Yes, sir. You mentioned IPAB and how, well, your description of it, we're very familiar with it, especially Kendall Antikire. She handles healthcare policy for us. But, I mean, the IPAB and the way it was structured, and that there's a window about this small to
31 days.
And all that, I mean, that is obviously unconstitutional. And with the challenges to Obamacare, I've always wondered, when is that IPAB challenge going to come? Why can't they just put a target on IPAB and say, instead of the way they've done it now with the individual mandate to make it all crumble, why not IPAB and make it crumble? Because I know Congress has passed a bill, you know, destroying IPAB and all that sort of thing, but why hasn't there been a legal strategy to go after Obamacare through that?
I can't answer the question, but you and I know that the Supremes are taking a look at PPACA in its entirety, to see whether or not the mandate is going to be struck down, which in case would take down probably the rest of the law for lack of funding. Any other comments on regulation? If not, thank you very much for giving me this opportunity. I appreciate it.
Okay.
Enjoy it.
It's really good.
Thank you very much. Appreciate it.
Yeah. Under a regulatory state. That's what's so good.
Doing the homework on this, I found there's so much to it,
Right.
because it's not even and digging into the details, well, just we have someone
Plus, like you said, the whole study costs